Hello, everyone, and welcome to my case summary of Celotex Corp versus Catrett. This is a Supreme Court decision all about summary judgment, and you will almost certainly read this one in a civil procedure course in law school. It's one of the most cited decisions ever in history. It's from 1986, and it's an opinion by then Associate Justice Rehnquist. It's a 5-4 decision, too, and because of that, there's a very important concurrence in there by Justice White that we will get to at the end. So, what happened in Celotex? Well, the plaintiff, Mrs. Catrett, claimed her husband's death from asbestosis resulted from exposure to some products from multiple defendants, including Celotex. So, Celotex moves for summary judgment under FRCP 56. They argue that the plaintiff had not produced any evidence that her husband had been exposed to Celotex's products. So, she responds by identifying 3 pieces of evidence that do support her husband's exposure to the products in response to this summary judgment motion. But the district court grants the motion for summary judgment, so Celotex wins at the trial level. But then at the Court of Appeals level, they reverse, and they hold that Celotex failed to support their motion with evidence tending to negate such exposure, and this precluded the entry of summary judgment in their favor. So the Supreme Court granted certiorari, so they need to resolve what is the appropriate standard for summary judgment? What do defendants moving for summary judgment need to bring to the table? And what do they say? Well, the Court of Appeals is wrong here. They find no express or implied requirement in 56C that the moving party support its motion with affidavits or other material that negates the opponent's claim. And in fact, they say that Rule 56 suggests the opposite of that there is no burden of doing that. And they point to the language, the affidavits, if any, that's a direct quote from the rule, suggests the absence of that requirement. And then they point out Rule 56A and 56B say parties clearly may move for summary judgment with or without supporting affidavits. Then we get this concurrence from Boyer and White that I said. It is not enough to move for summary judgment without supporting the motion in any way or with a conclusory assertion that the plaintiff has no evidence to prove his case. So this is important since Justice White provided the crucial 5th vote. When a concurrence comes in there and agrees on the narrowest grounds with the other 4 justices or whatever is in the majority, that concurrence is actually binding law. Normally concurrences are not, but this one is. That's under the Marks rule, which is a Supreme Court decision from 1977. So yeah, this is the law of the land. You can kind of see, he mentions the word conclusory, and we all know, if you've read Iqbal and Twombly, which you probably have by this point, they're usually really early on in a Civ Pro class, but the Supreme Court hates conclusory stuff. It's a bad word. You don't want your allegations or assertions to be conclusory. You want to fill them up with facts, explanations, reasons. You don't just want to assert something and leave it at that, because that's conclusory and that's bad. So yeah, the bottom line is this. Summary judgment motions should be granted as long as whatever is before the court demonstrates that the standard for summary judgment has been met, regardless of whether or not affidavits were provided. So yeah, defendants need not worry about providing affidavits to support their motion for summary judgment. Just make sure your clients know that if you're doing defense litigation. And yeah, this is obviously a helpful case for defense side litigators. It came out in the big year along with some of those other summary judgment cases like Anderson versus Liberty Lobby. But yeah, this is a helpful case to know. And I think the White concurrence is probably the most important thing, actually, that it kind of tempered the majority opinion and said the defense still needs to do something in their opposition to summary judgment. They can't just hand wave the plaintiff's complaint away and say, this is bad. We need summary judgment. This doesn't have anything. So yeah, I hope that this video is helpful to you. I hope that you can use it, take it to the bank, and get an A++ in your civil procedure class. Or if you're an attorney, you found this helpful. This is, after all, one of the most cited cases ever. It's up there with like Anderson versus Liberty Lobby and Twombly. But yeah, As always, if you found this video interesting, helpful, or insightful, please leave a like, comment, or subscribe to the channel. And as always, thank you very much for watching. I look forward to speaking to you in the next video.